Hey everyone, welcome. I am absolutely thrilled you're joining us for today's Explainer because we are looking at a landmark legal judgment that honestly, literally reshaped a nation. We're talking about a moment when South Africa's highest court had to look its past dead in the eye to protect the most vulnerable people in its present. It's this massive story of law, culture, and at its core, human dignity. But before we get bogged down in complex legal frameworks and court documents, I want you to ask yourself a deeply personal question. If you die tomorrow without a will, who would protect your family, right? For most of us, we just kind of trust that the law is going to step in, a safety net to make sure our loved ones aren't left destitute. But imagine if that legal safety net was actually custom built to exclude them entirely. That terrifying hypothetical, that was the actual day-to-day reality for millions of South Africans, right up until this 2004 constitutional court case. We're going to see how a few unbelievably brave individuals took a stand against profound systemic inequality. They ended up completely redefining inheritance rights and finally dismantled an apartheid-era law that had somehow survived way into the country's democratic era.
Okay, let's dive into this. Here is our roadmap for today's explainer. 1. Real people, real stakes. 2. An apartheid-era relic. 3. The rule of primogeniture. 4. The constitutional rights clash. And 5. A landmark legal remedy. Let's get started.
Section 1. Real people, real stakes. The Bhe and Shibi cases. You know, it's absolutely crucial we don't just treat this as abstract legal theory. Every monumental shift in constitutional law starts with real, often devastating human stories. And this battle was sparked by ordinary women and children. Take Mrs. Bhe and her 2 young daughters. They were poor, completely dependent on the girl's father, and living with him in a temporary shelter in Khayelitsha. When he died, a local magistrate appointed the deceased father, the girl's grandfather, who lived hundreds of miles away in the Eastern Cape, as the sole heir. His plan? Sell the shelter to pay for funeral expenses. Under the law at the time, he was perfectly allowed to leave Mrs. Bhe and her 2 young daughters facing absolute homelessness. And the crazy thing is, this wasn't just some isolated mistake. Let's look at Charlotte Shibi's story. Her brother died in Pretoria, he wasn't married, had no kids. Naturally, as his sister, you'd think she'd inherit, right? Well, no. Her brother's estate was awarded to 2 male cousins, purely because she was a woman. One of those cousins actually misappropriated the estate funds, and the legal system's response was just to legally hand the remaining money over to the other male cousin. Charlotte was completely bypassed. So, to really understand how this could even happen, we need to demystify a bit of legal jargon: intestate succession. Simply put, intestate succession is just the set of legal rules that dictate how your property is distributed if you die without a valid will. Keep that term in mind because it is essentially the entire battlefield for this constitutional showdown. Section 2, an apartheid-era relic, the Black Administration Act. Now, this systemic legal barrier that was causing all this human suffering, it didn't just appear out of thin air. It was a very deliberate piece of legislation called the Black Administration Act of 1927. The system was completely divided. If you were classified as European, your estate was governed by the Intestate Succession Act, which meant legal equality and protection for your spouse and kids. But if the system classified you as Black, you were shunted completely out of those protections and placed under Section 23 of the Black Administration Act, a totally separate, incredibly unequal system based unapologetically on race. When the Constitutional Court looked at this, they did not mince words. Justice Ngobo hit the nail on the head, describing it as, quote, an egregious apartheid law which anachronistically has survived our transition to a non-racial democracy. It was a law quite literally built from the ground up for separation, exclusion, and oppression. And Justice Sachs delivered this incredibly powerful thought, saying, it is an affront to all of us that people are still treated as Blacks rather than as ordinary persons seeking to wind up a deceased estate. See, the government had actually tried to argue that keeping this separate administration was sometimes convenient or inexpensive, but the court shut that down immediately. They made it crystal clear. Absolutely no amount of administrative convenience could ever justify the horrific indignity of racial discrimination. Section 3. The rule of primogeniture. The customary law conflict. So it wasn't just his racist 1927 act on trial here. The court also had to tackle the customary law conflict sitting right at the heart of these inheritances. The specific mechanism that locked out Miss Bhe's daughters and Charlotte Shibi is called male primogeniture. This is a rule where property and status pass exclusively to the eldest male relative. It totally excludes women, female children, younger sons, and extramarital children. Now, historically, this rule actually had a purpose. The male heir was supposed to step into the shoes of the family head and take on the absolute duty to maintain and support all the dependent members of the extended family. But here is where it gets really fascinating. There was a massive gap between official customary law and living customary law. Back during the colonial era, administrators essentially took the patriarchal features of customary law, exaggerated them, and trapped them in textbooks and legislation. The law became ossified, fossilized. But living customary law, that's dynamic. It evolves with the people. In a modern urban setting, an heir might just take the property and totally abandon the family, leaving widows and children destitute. True living customary law naturally adapts to sustain the modern family. But the courts were still stubbornly enforcing those rigid, outdated textbook rules. Section 4. The Constitutional Rights Clash. Archaic Laws versus the Bill of Rights. So here we are at the epic constitutional showdown. In one corner, you have these archaic fossilized laws. In the other, the modern South African Constitution, and the older laws were explicitly violating 3 foundational rights. Number 1, Section 9, the right to equality, because the laws were discriminating based on race, gender, and birth status. Number 2, Section 10, human dignity. Treating people differently based on skin color or implying women aren't fit to own property, that is an extreme affront to human dignity. And number 3, Section 28, children's rights. These rules completely failed to protect the best interests of vulnerable children like Ms. B's 2 little girls. The court also made a really important point about extramarital birth. The Constitution explicitly prohibits unfair discrimination based on birth. So the court ruled emphatically that a child's rights absolutely cannot be diminished just because of their parents' marital status when they were conceived or born. The law had to step up and remove that deeply harmful social and legal stigma. Kids born out of wedlock deserved the exact same protection. Section 5, a landmark legal remedy, protecting the vulnerable. Okay, so it's one thing for a court to just declare a law unconstitutional, right? But practically, if they just struck these rules down and walked away, there'd be a massive legal vacuum. Millions of people would have 0 rules governing their estates while Parliament took years to write a new law. To stop that chaos and protect vulnerable groups right away, the court crafted an immediate 3-step remedy. Step 1, strike down Section 23 of the Black Administration Act entirely. Step 2, strike down the customary rule of male primogeniture as it applied to intestate succession. Step 3, rule that until Parliament passes new legislation, the standard Intestate Succession Act applies to absolutely everyone, regardless of race. But the court was super perceptive here. They knew the standard Intestate Succession Act was basically built for a Western nuclear family model. It only recognized one surviving spouse. So what about people in polygynous customary marriages? To make sure literally nobody was left behind, the court innovatively tailored the rules right there on the spot. They modified the application of the act so that if someone had multiple spouses in a polygynous union, all those spouses would receive equal shares. They stretched that legal safety net to protect all family structures. As we wrap up this explainer, I really want to leave you with a provocative thought, one that echoes way beyond this specific 2004 case. Think about this. How must modern laws adapt to living, breathing cultures rather than trapping them in the past? Because this case wasn't about destroying customary law. It was about rescuing it from colonial-era fossilization and bringing it in line with modern human rights and dignity. It's a powerful reminder that the law has to serve people as they actually live today, not as they were categorized decades ago. Thank you so much for joining me to explore this incredible legal milestone. Keep asking questions and keep learning.